Okay, if you're a law student, you know this feeling. Staring at an essay exam and the panic starts to set in. But what if I told you there's a repeatable system, a method you can use every single time to turn that anxiety into a high-scoring, killer answer? Well, that's exactly what we're going to break down today. Let's get right into it.
Right? We've all been there. You're staring at this wall of text, this complicated story, and the clock is just ticking away loud. Your brain is scrambling, trying to spot all the issues, remember the exact wording of the rules, and somehow you have to weave all of that into an argument that actually makes sense. It's probably the most universal stress in all of law school.
And that's the real question, isn't it? How do you take this messy, jumbled story and transform it into the clean, logical, structured legal reasoning that your professors are actually looking for? Because the exam isn't just about retelling the story, it's about taking it apart like a puzzle. And today, we're going to solve that puzzle.
So here's our game plan. First, we'll talk about the main challenge. Then I'll give you the 7-step blueprint. We'll put it to the test with a case study, Pete versus Patricia, using something called the Mini-IRAC method. And finally, we'll see what the finished product looks like. Let's do it.
You know, the hardest part is often just starting. That blank page can feel impossible. It's so easy to just freeze up, or worse, to fall into the biggest trap of all, just retelling the story you just read. But that's narration, not legal analysis. And narration, let me tell you, does not get you points. Believe me, law school graders see the same exact mistakes exam after exam. Students will just dive in, writing whatever comes to mind without any organization. Or they'll mash the issue, the rule, and the analysis all into one giant confusing sentence. Our 7-step method is designed specifically to stop you from making any of these classic mistakes. So how do we fix all this? Simple. We use a system. And I want you to think of this 7-step blueprint as a reliable machine. It's not magic. It's a process you can follow every single time to turn those raw, messy facts into a polished, high-quality legal essay. It takes all the guesswork and the panic right out of the equation. And here they are, the 7 steps. First, and this is crucial, read the call of the question. Know exactly what you're being asked to do before you do anything else. Then, read the facts, spot the big issues, and draft a super quick outline. Now pay attention to step 5, reread the facts. This is your secret weapon. You'll catch details everyone else missed. Only then do you start writing using the IRAC structure, and you finish by directly answering that call. See? It's a system, and it flat out works. All right, enough with the theory. Let's actually put this blueprint into practice. We are going to break down a classic negligence fact pattern. Let's call it the case of Pete versus Patricia. This is where you'll see exactly how these steps come to life in a real scenario. Okay, let's look at the facts. We've got 12-year-old Pete. He gets a brand new bike. To look cool for his friends, he starts showing off, riding way too fast on the sidewalk. He loses control, swerves into the street, and bam, he hits Patricia, a pedestrian, breaking her leg. The question we have to answer is whether Pete is liable to Patricia for negligence. As I was telling that story, I bet you were already spotting the legally important facts. So, how do we tackle a big claim like negligence with our system? Here's the secret. You break it down. Don't look at it as one giant problem. Instead, you see it as a series of smaller, bite-sized problems. We're going to use a mini-IRAC for each and every element of the claim. This is how you build your argument, piece by piece, like you're building with Legos.
First things first, we need our main overarching rule. What is negligence? It's when someone's failure to be reasonably careful creates an unreasonable risk of harm, and that failure actually causes an injury. Right there in that definition, we have our roadmap. We need to analyze duty, breach, causation, and damagers.
Okay, let's start our first mini-IRAC with the first element, duty. The rule is pretty straightforward. You owe a duty of reasonable care to people who could foreseeably be harmed by your actions. So, the very first question we have to ask ourselves is, was Patricia a foreseeable plaintiff? Let's apply that rule. Did Pete owe Patricia a duty? The answer is a clear yes. Why? Because she was totally foreseeable. He's riding a bike on a sidewalk. It is incredibly foreseeable that if you lose control, you might hit a pedestrian nearby. Boom, element 1 is done.
Next up, standard of care. And here's a little wrinkle. Pete's a kid, right? So we don't hold him to the same standard as a reasonable adult. The law has a special, modified rule for this. We ask, how would a reasonable child of the same age, intelligence, and experience have acted?
So, Pete is being compared to a reasonable 12-year-old. And let's be honest, would a reasonable 12-year-old understand that riding your bike like a maniac is dangerous and could hurt someone? Yeah, absolutely. You don't need to be a lawyer to know that. So we've established the standard of care.
Okay, now for breach. Did Pete's actions fall below that standard of care? The way we figure this out is with a balancing test. Think of it like a seesaw. A duty is breached if the risk of harm from your actions heavily outweighs any social benefit or utility of those actions.
Applying this test to our facts is, well, it's a slam dunk. Pete absolutely breached his duty. The risk of harm? Super high. You could cause a serious injury. And the social utility? The benefit? It was literally zero. He was just showing off. The massive risk completely outweighs that tiny benefit. So his conduct was unreasonable. That's a breach. Moving on to causation. Now this one's a two-parter, and you have to prove both. It's a two-for-one deal. The breach has to be the actual cause, we call that the but-for cause, and the proximate cause, which is all about foreseeability. If you're missing even one of these, the whole negligence claim falls apart. So let's break it down. Actual cause is simple. We just ask, but for Pete riding his bike recklessly, would Patricia have a broken leg? Nope. So that's met. Then proximate cause asks, was this type of harm a foreseeable result of his actions? Was it foreseeable that riding crazy on a bike could lead to hitting a pedestrian? You bet it was. So both parts of causation are met. Check and check. And finally, we get to the last piece of the puzzle, damages. This is usually the most straightforward element. For a negligence claim to succeed, the plaintiff has to show they suffered some kind of actual harm or loss, like a physical injury or damage to their property. And here, the facts make it easy. Did Patricia suffer damages? Yeah, she has a broken leg. That's a textbook physical injury. It clearly satisfies the legal requirement for actual harm. And just like that, we've now successfully analyzed all 5 elements of negligence.
Okay, so we built all the individual pieces using our mini-IRACs. We laid all the bricks. Now it's time to step back and see how they come together to form that polished, confident, high-scoring answer that directly addresses the call of the question.
And there it is. That one beautiful sentence is the grand finale of our entire analysis. It's not a guess, it's not a maybe, it's a firm conclusion that is supported by every single step of the reasoning we just walked through. It's direct, it's confident, and it proves you didn't just read the story. You analyzed it like a lawyer.
And that right there is the most important thing to take away from all of this. Your goal on a law school exam is to write like a lawyer, not a narrator. You're not there to tell a story. You are there to deconstruct a story and build a legal argument. Your job is to be an analyst. And when you use a structured system like this one, you guarantee that's exactly what you're doing every single time.